This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Still in consideration, and we're now looking at the necessity for consideration to be sufficient to merit the title. It needn't be adequate. And on this particular page of the course notes, you'll see there are a number of cases again. So I shall repeat, no need to know the case names, but it is necessary to remember the principles that were established by those cases or that were reinforced by those cases. So consideration is sufficient, not necessarily adequate. The courts will not look at the adequacy of agreed consideration. If you promise to give me a biro in exchange for my promise to transfer my £40,000 car, well, you have given me something, or promised to give me something of value, and in exchange I have promised to give you something of value, and the court won't look and say, this is ridiculous. A biro is not worth a £40,000 car. No. You promised to give me something of value. It may only be minimal value, but at least it has a value. The court once said, and I shall draw for you. I wonder if I can do it in black. Yeah. That's about the size of a peppercorn. Maybe it's a bit big for a peppercorn. And the court said in a particular case, a peppercorn has a value. And even though the recipient may not like pepper and throws away the corn, it still has a value. And that's where the expression of peppercorn rent comes from. A peppercorn rent is a rent that you pay. It's not adequate for the premises that you're renting. It may only be a £10 for a year's rent, but it's a peppercorn rent. It's a value. A peppercorn has a value. And even though the recipient may not like pepper and throws away the corn, it still had a value. So the courts won't look at adequacy, but they will look to see that it has a value sufficient to merit the title. Chappell & Co. and Nestle. Nestle's the chocolate people. And they were advertising, promoting their new chocolate bar called Five Boys. And I remember the bar, and it had a wrapping on it. And the wrapping had a picture of five boys: desperation, anticipation, satisfaction. And five boys with different expressions on them. And they were promoting this, and in their promotion they said, we will give a copy of the record Dancing Shoes. A copy of the record Dancing, a record is like an old CD, a copy of the record Dancing Shoes, plus in exchange for £1 shilling and sixpence, which equates to about 7.5 pence today. £1 shilling and sixpence, and three sweet wrappings. 3 wrappings showing the five boys, the picture of five boys. And Chappell were the promoters of this record. We have Dancing Shoes, Rocking Shoes, not Dancing Shoes, Rocking Shoes. And they were the promoters of this record, and they said, no, you can't do that, because there is a resale price agreement, which was legal at the time. There's a resale price agreement that says that this record shall not be distributed for less than 3 shillings and 9 pence. Now, 3 shillings and 9 pence equates to about 38 new pence, rather than the 7.5 pence and 3 sweet wrappings. And it was established that when people were sending in their 1 shilling and sixpence, their 7.5p, and their 3 sweet wrappings, the staff at Nestle would empty out the coins and put them on one side, would get the sweet wrappings and put them straight in the bin. They didn't even count the sweet wrappings. They just took the sweet wrappings, put them in the bin, got the name and address of the person that sent them in, and sent them a copy of the record while stocks last. And so it was claimed that Nestle were distributing this record not at 3 shillings and 9 pence, the minimum price, but they're distributing it instead for 1 shilling and 6 pence. And Nestle said, no, we're not. We're selling it for 1 shilling and 6 pence and 3 sweet wrappings. And the court said, well, all right. Why do 3 sweet wrappings have a value? And they said, because it's proof to us that someone, not necessarily the person selling them in, but someone has bought our promoted chocolate bar, 5 boys. And it was accepted that 1 and 6 pence plus the value attributable to these 3 sweet wrappings was sufficient to merit the title consideration. Not looking at adequacy, we're not considering how much they were worth. Were they worth 2 shillings and 6pence to get to the 3 shillings and 9 pence record? We're not looking at that. We're just looking to see, do they have a value? Yes, they did. So sweetie wrappings can, may, and did have a value. However, the acts that you perform, that you claim to be valuable and therefore sufficient to merit the title consideration, acts in accordance with a natural duty already owed are not sufficient. If you promise to look after a child, then that's a duty that you already owe. If it's your child, if you're a parent of the child, then your duty is a natural duty. You already owe that duty to look after the child. So that doesn't have a value sufficient to support another contract. Not sufficient in accordance with the legal duty already owed. Again, if you do something that you are already required to do by law, you can't claim that activity as being consideration for another contract. And not in accordance with the contract if you're already bound by contract to perform. Then simply by performing an existing contractual duty is not sufficient to support another contract. So those are 3 cases, and the next cases I'm not going to talk to you about. Just remember, acts in accordance with an existing duty, whether it be a natural duty, a legal duty, or a contractual duty. If it's in accordance with an existing duty, it's not sufficient to support another separate contract. But acts over and above a natural duty, acts over and above a legal duty, acts over and above a contractual duty, they are sufficient. So you have a contractual duty, but then you go the extra mile. You have a legal duty, but you go the extra mile. You have a natural duty, but you do extra. I'll just illustrate that natural duty one. The case of Ward and Byham. Ward and Byham was a young lady, boyfriend, boy very good friend. Young lady gets pregnant. Boyfriend finds out, she tells him, and he says, don't worry about it. I will look after you. I will support you and the baby. You go ahead and have the child. I don't want to marry you. You go ahead and have the child, and I will pay you £5 per week towards looking after the child. That's a natural duty for a mother, isn't it? I'm sorry, this is not intended to be sexist. I can't help it. That's the case. That's the natural duty. It's a mother's natural duty. In exchange for this £5 offer from the rat, the boyfriend, she says, well, in exchange, I shall look after the child, I shall keep it warm, and I shall keep it happy. So she had the child, and he paid £5, and then he didn't pay her any more. So she said, where's my money? I need the money. He said, sorry, no, it's a mother's natural duty to look after the child. And so he went to court. And she said, he promised that he would pay me £5. What did you give him in exchange? She said, I promised to look after the child. I promised to keep it warm. I promised to keep it happy. And the court said, well, yes, okay. It is a mother's natural duty to look after the child, said the court. It is a mother's natural duty. But it's not also her natural duty to keep it warm and not to keep it happy. That's over and above a mother's natural duty, promising to keep the child happy. And so the £5 had to be paid. So the dirty rat had to pay. Over and above a legal duty. Yeah, that's okay. If you're performing, if you're acting in accordance with the duty already imposed upon you by law, that's not sufficient. But if you go beyond, that is sufficient. Over and above a contractual duty. Two similar cases here, Hartley and Ponsonby and Stilk and Myrick, the two similar cases. I'm not telling you about them. Just remember, if your actions are in accordance with an existing duty, they're not sufficient to support the title of consideration in support of another agreement. But if they're over and above a legal duty already owed, a contractual duty already owed, a natural duty already owed, then they are sufficient to support a separate contract beyond. Williams and Roffey. Acts in accordance were then changed. You were acting in accordance. You had to finish a job by 31st of October. The builder says, I'm not going to be able to finish not until 30th of November. And it's the other way. It had to be finished, the building alteration had to be finished by 30th of November. And the builder said, I'm not going to be able to do it. I won't be able to finish until 31st December. And this was stated on the 31st October. The contract said finish on 30th November. And the hotel venue, marriage venue owner said, no, you've got to finish. It's got to be finished by 30th November. Otherwise, we're going to lose all the Christmas trade. I've got wedding parties booked. We're going to miss all the trade for Christmas and the New Year. No, I don't care what it costs. I don't care what it costs. Employ many more subcontractors to come in, but it has to be finished by 30th November. So the main builder, the contracted builder, called in all the favours and called in all these subcontractors, paid overtime. They were working 36 hours a day, these people, desperate to get the job finished. And on the 29th of November, the builder said, we did it. I didn't think we would, but we've done it. We finished, job's complete, there you go. And the hotel owner said, thank you so much. There's the 10,000, the contract price. And the builder said, well, what about the extra that you promised? No matter how much it costs, you promised to pay whatever it costs to get it finished on time. And the hotel owner said, all you've done is complete the job in accordance with the original contract. Now, what else have you done? The performance of an existing contractual duty already owed is not sufficient to support a new contract, another contract. So it went to court. And it was determined by the court that when the hotel owner said, it's got to be finished, because otherwise I'm going to lose all my Christmas business, the 2 weddings I've already got booked, I'm going to lose all of that. It's got to be finished. That was the extra consideration. That he was saying, I'm going to lose all this business. And the builder was giving the consideration that said, I will save you from losing all this income if you pay me the extra consideration. And that's what the court implied. They said, by identifying that you're going to lose business and income revenues, then by saving you from that loss, the builder was giving you additional consideration. So the builder won the case. If the hotel owner had said, you will complete by 30th of November, because otherwise I shall sue you for any loss of profits that I may sustain. If that's what had been said, then it's likely that the hotel owner would have won, because the builder was not made aware of the extent of or the existence of the possibility of a loss of profits. But he didn't. He said, if you don't finish by December, then I shall lose this, and this. And that was sufficient. Thomas and Thomas, nice case, and I shall tell you this one. Thomas and Thomas, of that family, I forgot the family name. Oh, yes, it was Thomas was the family name. Mrs. Thomas, Mr. and Mrs. Thomas. And he was in ill health, and he died. And Mrs. Thomas was there in her home, which was in his name, and he'd left it to the children. And the children said, Mum, don't worry about it. You stay here. You can stay here. Just pay us £10 a year rent. There you are. That makes you a lot happier. We know you're very sad about losing Dad, but you stay here as long as you want, £10 a year. So she did. And then the children decided they could do with getting Mum out. They wanted the money from the sale of the house. So they gave her notice to quit. Sorry, Mum, but you're on the streets. Out you go. And she said, no, you can't do that. I'm paying you £10 a year rent. And they said, £10 a year? £10 a year? This place is worth £300 a month. And you're paying us £10 a year. Out you go, old lady. So they went to court. The children took their mother to court, as you would. They took their mother to court, and the mother, legally represented, defended herself and said she's paying her rent. And the court said, a peppercorn has a value. And even though the recipient may not like pepper and throw away the corn, it still had a value. £10 a year is sufficient to merit the title consideration. And therefore, I promise to pay you £10 a year. You promise to let me stay in the premises, which are worth £400 a month. We have a contract. And so she stayed. And that's a happy story. And that, I think, will probably be sufficient before we get into privity of contract.